Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello everybody, how you doing today? We're here today to do a video here to look at a little bit more of the Banc oral arguments. I pulled out a couple pieces here. One piece from Luke Berg, and kind of illustrating some of his arguments, and then another piece from Miss Nyrider's portion, and also in this gonna kind of, to my mind, point out a little bit more of the disingenuous kind of conduct of the majority judges, but we'll get to that as we go here. So we're going to go ahead and start listening. We're going to start out with Luke Berg here, just a little bit after he mentioned, his little bit about Strain's credulity, or whatever. So it's going to, come into his argument here, and we're going to go ahead and go through, and then I'll pop in at certain points when I want to maybe call attention to something. So here we go. Hope you guys enjoy it. And one other thing I wanted to say is that for those of you I know, you find it hard to listen to this stuff of what happened to Brennan and all that, and it's difficult and it's painful in a way. And I appreciate, that you still come here and get vamped up on the fact that, it is an outrage, and I know it's unpleasant to kind of continue to go through some of these things, but I think it's necessary because we have to continue to find it unpleasant, because that's going to keep us talking about it, and that's ultimately what's going to help, find success for Brendan, I think, in my mind. So for all of you who, even though you find it unpleasant, still come here to keep the conversation going and to keep, all that stuff, to keep stoking the fire that I, have been kind of saying lately, that these really great documentaries have, kind of started. It's all part of it. And so I know, I appreciate the fact that some people out there find it, unpleasant, going through some of this stuff, but like I said, it's great that you continue to come back here, even though it is unpleasant, because it's important to keep the conversation going and that sort of stuff. So just wanted to mention that before we start as well. And so here we go.
On the trial court's opinion, and the trial court was much more thorough. It went through all of the relevant factors thoroughly. So this idea that it failed to actually consider the totality of the circumstances is outlandish, quite frankly.
Well, no, it's not outlandish at all. This case is very much like Brumfield against Kane from the Supreme Court, where somebody with a great number of limitations is pressured, and a person with a literal cast of mind being told, if you tell us the truth will make you free, a rather biblical allusion, of course, we know, and being told as many times as Dassey was, if you just work with us, everything will be fine, leading up to his saying, can I go to my 6th period class, suggests that there were false promises of lenience.
As we argued in our brief, courts have consistently held that there has to be a very specific offer for there to be a false promise of leniency.
But that's for a competent adult. I think this is where we're intersecting with the youth and the mental limitations, I'll just call it that. There's plenty of evidence, whether he's in the bottom 5% or the bottom 8%, whatever. But I believe that the standards that you're referring to are the reasonable adult standard, and the court has said in other cases that juveniles are not adults. Juveniles need a different test.
Yes, Mr. Berg in Wisconsin. In fact, Reed tells you themselves. They warn you themselves that using their technique on a, number one, a juvenile, and even more if you use it on a mentally limited one, that if you use the full Reed technique as you would on an adult, you're taking chances. They tell you that themselves. Anyway, so back to the oral arguments here.
Absolutely, that's right. But it's a totality of the circumstances test.
And here, the totality of circumstances showed he was told at least 28 times during the interview that everything was okay, that they already knew the truth, and it wasn't his fault. 28 times.
They also took numerous precautions to protect against Dassey misunderstanding anything they said.
Could you tell us what precautions they took?
Absolutely. They began the very first interview by telling Dassey, you can leave at any time, and you don't have to answer any of our questions. They repeated that.
Could I just ask, and because you mentioned the first interview, when we think of the totality of his interactions with the police officers, he sees these same officers on a couple of occasions, twice, and I believe it's the February 27th interview, then the March 1st interview. Shouldn't we evaluate his interactions with them on the basis of all of that, if we're really doing the totality?
Absolutely.
Okay.
And that's why I'm recounting some of the things.
So if Officer Fassender makes a promise of lenience in even one of the earlier ones, that's a problem.
I think that would be relevant, yes.
Yeah, so then in that February 27th, they actually said they were not acting as officers, but instead as fathers. So doesn't that confuse their roles and imply leniency to an intellectually or emotionally limited juvenile?
No.
Why not?
As I said, they warned Dassey he can leave at any time, and anything he said can be used against him. They repeated that warning throughout. At the end of that first interview, after making multiple...
So the fact that they said that they were acting as if they were his fathers, that doesn't have any bearing on it.
I think it's a factor, certainly, but it doesn't force the conclusion that his confession was involuntary.
Is it correct? Is it correct that Dassey told the police officers during the course of these interviews that his uncle had told him not to talk to the police?
Yes, that's right.
And I've forgotten the role that Avery's lawyer played in that, but that was one of his accounts. Is that right?
Yes, that's right.
Mm-hmm.
Okay, going to jump in here. Yes, but did Brendan Dassey truly understand his Miranda rights? Could he understand them? I don't think so, and I think that's illustrated in the way that he asks if he's going back to 6th period, and they tell him no, he's under arrest. And then he goes on further to say, is it only for one day? Right? This shows to me that Brendan did not understand his Miranda rights. It clearly illustrates that. And so to hear Luke Berg arguing the way he is just seems very disingenuous to me. And then to answer the bit about Uncle saying don't talk to the police, I'm sure that was the standard line at the Avery salvage, that they did not trust the police because of years of conflict with them. So I have no doubt that Stephen and many other people on the salvage yard said those words because they had no love for the police, which had wrongfully convicted their beloved family member and caused him to sit in jail for something he didn't commit, for a crime he didn't commit. So that's completely understandable. So, but anyway, they brought that up anyway, so here, let's move on.
I also want to point out that at the end of the very first interview, after making multiple vague assurances very similar to the ones they made on March 1st, the officers asked Dassey specifically. They said, did we make you any promises? Dassey said yes, that I could leave whenever I wanted, and I didn't have to answer any of your questions. I think that's pretty strong evidence that he didn't hear any promises from their sort of vague statements.
But how do we take can I go back to school? I mean, the kinds of things that they were eliciting from him with quite a bit of work, as Judge Rovner's opinion certainly amply documented. Most people who commit murder, dismemberment, and destruction of a corpse don't think they're just going to go back to school and turn in their 6th period project.
Most people, if they saw what Dassey saw, wouldn't have participated.
Well, but I'm just saying, doesn't that tell you that he is just a person who doesn't get it? They told him, if you talk to us, everything is going to be fine. We have your back. We're your father. Promises are made.
I think those statements show, at most, that Dassey doesn't understand how awful it is to rape and murder someone.
Yeah,
was he aware that his mother said it was all right for him to talk to you?
Absolutely. The officers asked both his mother and him for permission. They offered to let her sit in on the second interview. Both he and her declined. For the March 1st interview, they again asked both him and his mother for permission. They Mirandized him multiple times. In the second interview, they Mirandized him on the March 1st interview. They repeated those warnings before they started asking questions.
See, for me, this is just another very disingenuous bit from Luke Berg. Because, number one, they asked for permission on the 27th. Okay, but what at Fox Hills? What about at Fox Hills? What was going on there? Barb was there. You guys could have done this that day. And then we get to the last, just some disingenuous piece of this, where they say they gave her the opportunity to be there on the 1st. No, they waited until the 1st when they knew she would be in divorce court, most likely, because they had spent the entire previous day at Fox Hills with her and the boys. So she most likely mentioned that she had to be in court the next day, and that could be when they decided that they weren't going to do it there at Fox Hills, and decided they were going to do it the next day when they felt they could maybe have Barb out of the equation because she would be in divorce court. And that's where she was that day. Okay, other thing here. She gave her permission on March 1st, right? He says that. Well, let's analyze that a little bit. Fassbender and Uyghur call and ask if they can get Brendan and talk to him and all that sort of stuff. And she says, Barb answers, yes, if you bring him back to school. Okay, that's conditional, guys. You understand that, right? Conditional. Okay? The permission is conditional. If the conditions are not met, the permission is, revoked. You understand? Right? Am I clear on this? Okay. So, technically, no, they didn't have permission. I mean, in the end. And so, it's just ridiculous. And for me, like I said, it looks totally planned out, the way that they keep saying these things, but they waited until a day when they most likely knew Barb would be in divorce court, because like I said, they spent all day at Fox Hills with them before March 1st with Barb and everybody else. In fact, Barb felt intimidated. She felt like she couldn't leave Fox Hills. That if she perceived that she would be arrested or something would happen if she tried to leave Fox Hills. I mean, that's interesting, so anyways, and then they go ahead and wait till a day when she's going to be in court. I'm sure I'm sure she mentioned the fact that she had court the next day probably came up at Fox Hills. I can't say that for certain, but it would stand to reason why they ended up not doing it at Fox Hills when they had, whatever, they could have had a nice setup. And we have nothing of what happened at Fox Hills, by the way. That's the other thing. We have nothing of what happened there. Really. Nothing. Seriously. And so who knows what happened there? Was he Mirandized there? Was he, what happened at Fox Hills? It's just so it goes on and on. So that's what I feel is just very disingenuous about what you just heard Luke Berg saying, and we'll probably hear just a little bit more here as we go. So anyways, here we go. Back to the oral arguments.
Mr. Berg, what, if anything, should we make of the fact that in March of this year, one of the nation's largest police consulting firms, the one that trains officers in Chicago, New York, and federal agencies, has said that it's tossing out the Reed technique, the one that was used here, the interrogation technique used in this case, because of the high risk of false confessions. Do you take that into consideration at all?
Barely. The Constitution does not incorporate what a particular organization thinks are best practices. And just because that one organization thinks they are best practices doesn't mean that they in fact are best practices.
One institution that is now training the large city police forces and federal agencies. It's meaningless, right?
It's one organization among many, and this is a case that has obviously garnered a lot of attention, so the fact that they used it to get some attention of their own, I think, should not be given a whole lot of weight.
Can you give me the fact that they did not feed him? I mean, think of trying to get him to talk about that she was shot in the head. It's like a 20 questions game. I cut her hair. I slit her throat. You punched her. And finally he says, oh, come on, who shot her in the head? Over and over, the facts are given by the police officers to Dassey, and Dassey agrees with what they said.
Absolutely.
Until he goes out and talks to his mother and says, I didn't really do it. They got into my head.
I'll give you two very important details. Two details that he provided that weren't even suggested by the question that was asked of him. So early on, Dassey said that Avery put Teresa in the back of the truck. They asked him, was she dead? And he said, yes. And they said, Dassey, how do you know that? At that point, he realizes that he's been caught in a lie. And quite logically, but unexpectedly, he says, well, I was biking and I could hear it. They're like, what? Hear what? Screaming.
But there had been huge publicity about this case.
There wasn't publicity about her screaming, help me.
He knows that she's dead, right? As of the time of these 2 or 3 interviews. Everybody in the United States knows that she's dead by the time of these interviews.
Yes, that's true.
Right?
But he provided a lot of detail that he could not possibly have gotten from anywhere. I think the most telling examples are his memories of Teresa. He remembers her screaming, help me, and how she looked, naked and chained up to the bed. He remembered her crying. But they feed him that. I mean, that's not something that initially... In fact, there are contradictions in his accounts. The contradictions are rife. They didn't feed him the fact that she was handcuffed to the bed. That was another... But there's no evidence that she was either. They found handcuffs in the bedroom. But they didn't...
Does that mean... Does that lead to this?
Well, I will note that...
they found handcuffs in the bedroom?
I will note that the question of whether there was enough evidence is a question for the jury. Habeas is not a license for federal courts to play backup jury.
When we try to evaluate whether it was voluntary and whether some of this information was new or fresh, we can look at the corroborating circumstances around it, can't we? And that can certainly have some bearing on it, on the question.
I don't think you can. No, the Supreme Court has consistently said that reliability is a question for the jury. It's not something you consider on voluntariness. So there is a good answer. There's a lot of corroborating evidence in this case, but that's not something you consider in a habeas case.
Did any of this ever really get considered, though, is my question, you know? And the vivid detail, this stuff that he's offering, that Brendan offered, that vivid detail, the facts or whatever, it's like all of it, every bit of it is uncorroborated. Uncorroborated. Absolutely. All of it. I mean, how are you going to hang your hat on something you can't even prove happened? That's another thing about this that just kind of boggles my mind sometimes. And that's what they're basically telling him, like, it doesn't matter that the fact that what is being suggested here seems ridiculous and impossible. That's essentially what they were getting at, using legal terms and legal strategies to say it, but that's essentially what they were saying. It's like there's no proof, there's no evidence that there was handcuffs or anything on the head post or anything to suggest any of this happened. You know, and that's what they're pointing out point blank, and they're like, don't you think that's, you know, relevant, or, you know, don't you think that's significant or whatever? And he's like, no, I don't think it is. And, you know, he's just like quickly denying it. And so I just thought that's interesting. I just think that's interesting about Luke Berg. You know, he's just clearly not willing to look at the situation and see it for what it is. And it's like I said, even Judge Hamilton at some point ends up pointing to the fact, oh, remember, didn't he say that they stabbed her and they did this and that and these other things? It's like, yeah, once again, a bunch of things that are absolutely uncorroborated. And, you know, it's just ridiculous. So anyway, moving on.
Well, but so here we have to think of the theory that we're operating under. There's some discussion in both the briefs and the district court opinion of both D1 and D2. And in a D2 case, you are, in fact, looking at the evidence, which is why I mentioned earlier the Brumfield case, which is a square ruling by the Supreme Court of the United States relatively recently, finding an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. It's an Atkins claim, but it doesn't matter. It's a 2254 D2 claim. So I think we do have to look at the evidence here. But actually, I want you for a minute, if you just take 2 minutes of your argument time to discuss the ineffectiveness of Mr. Kaczynski, since the district court is obviously horrified by that. The state courts are horrified by his behavior. They remove him from the case. And he actually says at some point, I consider myself to be representing the victims. So why doesn't that fall within the Kyler against Sullivan conflict of interest rubric?
What Kaczynski did is absolutely indefensible. We haven't defended it.
Well, what do you know? Luke Berg actually said something that I can agree with him. Lynn Kaczynski is indefensible. I don't necessarily agree with him that they've never supported him or, anything like that. Don't really go along with that. You guys made him a judge. And he came right back around and gave you guys another black eye right when, you didn't need it after Making a Murderer came out. And so that's, it looks like karma's getting ready to get down in Wisconsin sometimes when you think about it, how these things are happening. But anyway, moving on.
But
so
he was
he's
removed.
Not representing it's as though it's worse than having no lawyer at all. He would have been better off pro se. He would have been better off with somebody who was not helping either the victim's family or the prosecution.
He was removed 8 months before trial.
But the harm was done. The harm in the term, you used these confessions at the trial. The harm was already done by the time Kaczynski leaves.
What he did had absolutely no effect on the primary confession, the March 1st confession. Kaczynski wasn't around until after the confession came in. So there's no arguable effect on the centerpiece
but
evidence.
He doesn't do anything to try to ameliorate this, to try to bring a solid defense of involuntariness of the confession.
That's absolutely not true. He moved to suppress the confession, and if you read the transcript, he made a lot of the same arguments that Dassey is now making on appeal.
I've read the transcript, of course.
Hey, judging by the fact that Len Kaczynski said in the press before ever meeting his client that he was morally and physically responsible or whatever for this and stuff, all that stuff that he said, how passionate or how good, how invested do you think Mr. Kaczynski was in arguing that motion to suppress the confession? Do you think his heart was in it? I sure don't.
Identified all of the same statements that Dassey has focused on, and he argued that it was coerced, and the court rejected that.
But of course, you don't have to show prejudice in a Kyler case. If you show conflicted counsel with an actual conflict of interest, you're done. The Sixth Amendment gives you the right to counsel.
You have to show an adverse effect.
Right.
But regardless, the Kyler claim is foreclosed on habeas because the Supreme Court clearly said in Mickens that Kyler is only clearly established for multiple concurrent representation. Nothing like that happens.
Well, and that's what I'm saying. I was looking at Mickens before this argument, and I don't see anything in Mickens that says the kind of conflicting concurrent representation has to be co-defendants. If he was essentially a member of the prosecution team, that's a party. That's a concurrent representation.
There is no allegation that he had any relationship with the prosecution, that he had any sort of financial incentives. He made some bad decisions.
Money doesn't matter.
Sure.
I mean, you could represent somebody without being compensated.
Well, we think the Kyler claim is clearly foreclosed by Mickens. It's a very clear statement from the Supreme Court. In Mickens, the court was considering successive representation. So you had a lawyer that was representing two different people. That's very close to multiple concurrent representation, and yet even there, the Supreme Court said that Sullivan doesn't clearly establish anything in that. Here you don't have anything like either multiple or successive representation. You have some bad decisions by counsel, sure.
Well, you have... I don't agree with that reading of Mickens, actually. So, because you do have active representation of conflicting interests.
Well, our position is that it's clearly foreclosed. So I'd like to move back to the voluntariness if I could. As we've argued...
And moving back to the voluntariness, when we look at the limitations Dassey had and his demeanor during the interviews, particularly when we look on the tape, you can see a significant change in his demeanor when he's left alone or when his mother enters the room.
I think that actually supports the state's position here. So at the end, if you watch the 20 minutes, rewatch the 20 minutes, when his mother comes in, he spends 10 minutes His mom is crying, saying, "Why did you do it? Why did you keep it a secret? Why didn't you tell me?" She says, "You knew it was wrong, right?" Looks like he nods. The whole time, he's got his head in his hands. He can't bring himself to look at her. And then when she leaves, he starts crying for the first time, the only time that I'm aware that he cries. And I think it's pretty clear that he's guilty. I think that's why he confessed, because he needed to get out all of those things that were in his mind. Now, I want to go back to the memories of Teresa that I was mentioning before, because I think that's one of the primary evidences that his confession was voluntary, the way he volunteered those details. He remembered her crying and pleading with him not to do it while he raped her. He remembered her desperately trying to move away as Avery came at her with a knife. He remembers her breathing after Avery stabbed her in the stomach, and that she's still struggling to breathe after he cut her throat. He remembers that her belly wasn't moving as they carried her out to the garage. And he remembered the awful smell as her body burned. None of those memories were suggested to him by the officers. They were very raw and they were very real. And Dassey needed to get them out. Another main piece of evidence that shows the voluntariness is the way he resisted the officers numerous times.
He's guessing. I mean, you see this as resistance. I see this as him sort of casting about. You see these long delays on the video where they ask him a question and he's obviously racking his brain as to how can I answer this in a way that you're going to like? How can I answer this, quote unquote, correctly? And, you know, I don't... His very diction is so unsophisticated. He just doesn't know what he's talking about.
The counter to that is that you have at least 35 different times that he resists the officer's questions. So they asked him 6 different questions on 4 separate occasions about whether he shot Teresa. And these were some of the most leading questions. They said, "We know you shot her too, isn't that right?" He says, "No." They say, "How many times did you shoot her when the gun was in your hands?" He says, "It never was in my hands."
So,
they asked 15 questions on 6 separate occasions about whether the fire was going when he got over there. He consistently said that it wasn't.
He answers every which way on some of these questions, whether it's about the fire, whether it's about where's the car in the garage, did you go first, did you go later? He's all over the map, and you can pick a sentence here and a sentence there and knit together a confession, but it's not what really happened.
It's true, he changes some details here and there.
Changes important details.
But that's exactly what you would expect.
And that's exactly right. Brendan is all over the map, guessing at what these guys wanted to hear. And then when they came back and wanted changes because they want to start placing things in the garage, things started changing. It's all just continually a changing story because he's trying to make it fit what they want to hear. He doesn't understand he's not a mind reader. And that's what this is. And hearing Luke Berg's arguments, here are just ridiculous to me. I just don't see it with what Luke Berg is trying to get at here, because the proof here is, or what we see here is nothing that Dassey offers on his own that can be corroborated. That's one big problem. You have the way that these 2 detectives are feeding everything to Brendan. That's a problem, and there's so many problems, and he does not acknowledge these problems. He won't, just like the state of Wisconsin, just why everything that makes this so suspicious in the first place, because they won't even acknowledge the simplest things. Anyway, so here we go.
For a traumatic memory like this, that's how memory works.
It's also what you would expect from somebody who is trying to say what the officers want to hear and isn't reading their mind.
Particularly because they show his frustration when he resists or disagrees with key details, and then they offer him praise, saying, "Oh, now we believe you," when he picks up on a fact that they have suggested to him when he's answered.
What you wouldn't expect if he truly had been coerced is that he would continue to resist the officers, and he did. There was 8 questions in a row about whether they used the wires in the garage for anything. He never gave in to that. Why not? If he gave in to everything else, why would he not give in to something like that?
Because he explains at one point, because he just couldn't think of anything. He couldn't come up with another thing to say, and he's at the end of his rope a few times and just has not enough imagination.
So you're talking about the question, who shot her in the head, and I think there's a very good explanation for why he couldn't think of it. Put yourselves in the investigator's shoes for a moment. They're trying to figure out what happened. They don't know the details.
They're telling him, we know everything, Brendan.
They know she was shot in the head, so they think that's how she died, and they're talking with Dassey about what happened in the bedroom. And then he says, Avery stabbed her, I cut her neck, Avery choked her, and they're thinking, well, she must be dead now, so why would Avery shoot a dead woman? That doesn't make any sense, so he must have shot her in the bedroom. And so they try and get to elicit that detail, and he can't think of it because his mind is in the bedroom. They don't find out until later that Avery actually shot her in the garage, like 10 minutes later. And so that's why Dassey couldn't think of it in the moment, because they have him focused in the bedroom. And so there's a very good explanation for why he couldn't think of it.
Which just goes to show all he's trying to do is figure out what's in their mind, how can I replicate what you're waiting to hear, and then you're going to praise me and say, good for you, you're going to feel better after this, and now we move on. And everything's going to be okay. We're in your corner, Brendan.
That doesn't explain all of the details that he volunteers that were never suggested to him. Colors, sounds, smells, all the memories of Teresa that I mentioned before.
Yeah, I'm not sure that all of we can discuss this with your opponents. I think that the list is, if not non-existent, very short. And he explains at the trial that he's made up some of those, quote, details from a book he read.
Yeah, I think that explanation is outlandish, quite frankly, especially because the detail that he's talking about, that Teresa was handcuffed to the bed, that came in response to a question that didn't even call for that detail. So they're walking him into the bedroom, and they ask him, was she alive? And he says, well, she was handcuffed to the bed. The idea that he, at that moment, suddenly conjured up this book that he read, decided to make up a story and pull a detail from it, just beggars belief.
Why? He's in fantasy land anyway, and there's no sign on the headboard of handcuffs. I mean, she would have been handcuffed.
Or possibly he was remembering. He was in his mind and he remembered the detail. He remembered vividly the image of Teresa handcuffed to the bed, and he brought forth that detail when they asked, was she alive? Nothing the investigators said came even close to a specific promise.
The investigators made my skin crawl watching this video, this lulling behavior that they conveyed, which was so dishonest, with such a vulnerable person. It was not what I would call an interrogation. It was tell me what I want to hear.
There was some minor deception, to be sure, but the cases say that that's okay. No, right. I don't think it was major. A lot of the things that the investigators actually said were true.
Psychological coercion.
A lot of the things that they told him were true. So their statements, will go to bat for you, for example. They did, in fact, go to bat for him.
If he had stuck with his story and testified against Avery, I suspect they would have.
That's exactly right.
Okay, so what I wanted to just point out for you real quick at the end of Luke Berg's little segment there, before we go into Miss Nyrider here, is you got that at the end there where Judge Hamilton said, oh, well, they probably would have went to bat for him if he would have cooperated in getting the conviction against Stephen Avery, right? Showing that they clearly have an understanding of what the state or the prosecution gets out of the confession from Brendan Dassey, and therefore it's very crucial as to whether or not it was voluntary or not. They clearly understand what was going on, that it was being used to help to, potentially help to convict Stephen Avery, right? They clearly understand that point, as is illustrated there by Judge Hamilton, right? Okay, keep that in mind as we go through the Laura Nyrider segment here. Here we go.
That's why the moment when Brendan Dassey asks to go back to school is so powerful. It speaks to his understanding of the bargain that has been struck.
So I would like your response to the points Mr. Berg was making about facts that Dassey furnished that were not fed to him by the police officers or the media.
Indeed, Your Honor, most of the facts that were listed in the panel dissenting opinion were in fact fed to him often on February 27th. The whole notion that a rape was involved at all in this crime was fed on February 27th when the officers asked Brendan Did he try to have sex with her or anything? And she said no. It's very important. We had heard that he might have told you that. The notion that Brendan had participated in burning the body, also on February 27th. Brendan, I'm going to ask you a difficult question, okay? Did you help him put that body in the fire? If you did, it's okay. Seeing body parts in the fire, this is a telling moment on February 27th. When the officers tell him, Brendan, I find it very hard to believe that you didn't see something in that fire. A hand, a foot, a head, something in that fire. And then he repeats back those same body parts, fingers, toes, and a forehead that he saw in the fire. The smell was fed to him. On March 1st, we talked Monday night about bad smells and stuff. Do you remember any smells coming from that fire after she was put on there? Going
this
inside.
A fire that had tires in it too?
I'm sorry?
This fire included tires?
It did include
which don't
tires.
smell that great when they burn either.
It did. The notion that he went inside Avery's trailer. Be honest, you went inside, didn't you? Hallbach's words, even her words during the supposed rape, were fed to Brendan Dassey. Was she saying anything while you were doing this? Did she ask you not to do this to her? And Brendan says, she told me not to do it. Tying Teresa Hallbach up. You helped to tie her up, though, didn't you, Brendan? Because he couldn't tie her up alone. There's no way. On and on and on, these facts were fed. A few of these...
So what about the ones that were supposedly not fed that your opponent mentioned?
Well, the majority, the vast majority of this confession was fed to him.
Yeah, but even if it's only a few, that would be worth attending to. A state court might think.
There were moments when the investigators, after steering Brendan down a path, allowed him to offer a story without fact-feeding. And at that moment, you can see him drawing on various sources for these details. Often what he drew on was details that had been circulated in the media. For example, her blood being found in the back of the RAV4. That's the detail that he knows was the case, and that explains his initial story, that he had seen her in the back of the RAV4. He also draws on the book Kiss the Girls at times, a book that includes hair cutting of a rape victim. That's where that part of that story comes from. And a few
details. I find at least some interesting tension between this theory. Do we know, for example, the level of writing and comprehensibility of that book?
Your Honor, that is an interesting thing, but the IQ...
Or how closely he followed the media reports so as to remember every detail, this boy with limited intelligence?
Both of those things are in the record, Your Honor. The IQ tests that Brendan was given repeatedly over time demonstrate that his limitations are primarily with respect to oral communication, verbal communication, but he can read and comprehend at a much higher level. This was a consistent result over time. And as for his exposure to the media reports, there was testimony at post-conviction from Brendan's mother, Barb, that the family regularly had the TV on. And of course, the story that was being told on the news was the story of their relative, Stephen Avery's arrest. The family was closely following this, and why wouldn't they? Not only did it implicate their family member, but it implicated their home and their livelihood. That's where he got some of these additional pieces of information from. The state of Wisconsin views this confession as corroborated, but in fact the corroboration on which it hangs its hat was a product also of the fact-feeding that occurred during this interrogation. They point to the bullet found in the garage, but it was the interrogators themselves who took Brendan Dassey into that garage. Originally, he had the shooting occurring outside the garage, near the bonfire pit, and it is them who say, Brendan, we need to get the accuracy about the garage. Why do they think it happened in the garage? Because they had previously found shell casings in that garage.
The motive of the police was to get a second killer?
I'm sorry, Your Honor?
What was the motive of the police in doing this? Get a second killer?
Your Honor, the test does not direct us.
No, I know that's not the test. That's the question I'm asking you.
The record doesn't speak to the motive of the police in this case.
Okay, so here we have Judge Can of the majority, right? And I've just played, you guys, I just pointed out to the clip to you, where it's clearly established that Judge Hamilton, illustrates that the prosecution was looking to get Brendan to testify or to use Brendan's confession against Stephen or whatever, that they wanted Brendan to cooperate, right? He clearly establishes that would have been the positive outcome for the prosecution by getting this confession from Brendan. Then we have Judge Can here, who's acting like that never happened, like that was never said, and now he's trying to act like play dumb on this and say what was the motive of the officers? What was the motive of the officers in this? To get 2 killers? So he basically wants to play it both ways. They want to be able to say when it helps, their argument, the majority's argument, that had Brendan stuck with his confession or whatever, then Tom Fassbender and Mark Wiegert would have went to bat for him, right? And they're willing to accept that there was a positive outcome for this for the prosecution and for the officers. And so they're willing to accept that then. But now when they're trying to, use this against Laura in her arguments, and they're trying to say, what is the motive of the police? Like, as if they didn't just say what it was earlier. I mean, that's just, to me, what strikes me about this. Not to mention that Judge Can has a lot of difficulty articulating what he wants to say, which I also think is interesting. It's like I said, dude, this guy reminds me of the dozing grandpa who is comes out of his little dozing, thing and starts yelling at the kids to get off his lawn. I swear. I mean, I keep making that analogy because it just seems so apt with him. So anyways, we'll go on to the rest of it here.
You're arguing their motive.
I am not, Your Honor. In fact, the district court here, in granting relief, pointed out that the police may well have simply failed to appreciate the way in which their words landed on Brendan Dassey. And that may well be the case in this case, but it does not preclude relief. In fact, it still bolsters relief under the principles of Miller versus Fenton.
So they needed two killers.
No, Your Honor, they needed the truth. But the problem with this interrogation is that the way in which they pressured and pursued Brendan Dassey was in direct contravention of the seeking of the truth. That's the problem here. They may have failed to appreciate it at the time, but that is not the relevant inquiry.
Yeah, Judge Can, that's not the relevant inquiry here. Come on, buddy. Get on board. So I hope I pointed out some interesting things here. Number one, I liked the fact that Luke Berg goes through all that stuff about all this vivid detail that Dassey offered and everything, and the judges are just shooting holes in it. Then at the beginning of when Laura begins to speak, she goes back and starts talking about the list, in the state's arguments, and starts, just dismantling it one by one. There's so much going on here, and then we add to that the disingenuousness, really, of the on-bank majority here. I mean, you clearly hear Hamilton acknowledge the fact that, yes, getting the confession from Dassey would have been helpful to the state and to investigators because they were trying to get his uncle, Stephen. And had Brendan Dassey cooperated or whatever, the Fassbender and Wiegert would have went to bat for him. So it's like they're willing to acknowledge it then because they feel it helps the argument, right? That, that Fassbender and Wiegert are good guys and that they would have, if he wouldn't have recanted, okay? So it's like you show a clear understanding of what the state stands to gain from Brendan's confession. And for Judge Can to be coming in the way he is, totally like old grandpa, get you kids get off my lawn style, they needed 2 victims. I mean, they needed 2 killers. It's just like, oh, dude, what? Do you know what you're trying to say? Anyway, so I decided to put this in just for kicks, but I'm drinking Blue Moon tonight, folks, because I'll tell you what, it's going to be a blue moon before I can ever go along with anything I hear coming out of the state of Wisconsin. So, or even this on-bank majority. So anyways, just thought I'd throw that in. Just wanted to pull out these selected little bits. Hope you guys enjoyed it. If you haven't already, please hit subscribe, and we'll see you.